Friends, this is the beginning of a new series of presentations that I'll be doing with Indus University, decoding various laws that have been enacted in the last 30 years in the name of strengthening women's rights and protecting them from harm and wrongdoing. The topic for today is the anti-rape law. And the question I'm asking is, when we enact these laws, is it gender justice we're looking for, or are we moving in the direction of full-scale gender war? Many people who've known my work with Manushi, which was founded in 1978, found it very strange that last year I filed a public interest litigation in Delhi High Court challenging draconian provisions of the anti-rape law, notably some of the provisions that were added through a special amendment in 2013. And people were surprised, given Manushi's long history of having played a leading role in giving voice to women victims of sexual harassment, violence, rape, and general atrocities. In fact, we published countless accounts, including first-person accounts of women victims of rape. And this was very unusual for the time when women began through Manushi to speak in their own name. And it gave confidence and encouragement to many more women to stand up and raise their voice against injustice being done to them. Manushi also provided legal aid, moral aid, moral support, counseling, and other manners of support, including shelter, to many victims of rape in its early years. And in fact, one of the most successful campaigns against sexual harassment, sexual abuse, and rape by a person in authority was led by Manushi. This was a case of a department head in Delhi University who used the insecure job status of young faculty members under him, and he employed mainly young women, to submit to forced sex and all manners of indignities. And Manushi had led a very successful, very powerful campaign in Delhi University on this issue, when actually whole university joined together and even closed down for a day or two, demanding justice. So with that kind of history of having helped countless rape victims, victims of sexual abuse, sexual harassment at workplace, people were very surprised that I began to critique the draconian provisions of anti-rape law enacted in 2013. In fact, even before this law was enacted, the amendments were enacted, I had made submissions before the Justice Verma Commission that the amendments they had in mind were going to cause havoc because they contained the same kind of lawless provisions that have become typical of many laws that have been enacted in India in the name of empowering women. And my long experience of providing legal aid had given me a fairly good idea of what works and what kind of laws are easy to abuse for filing false cases for purpose of blackmail and extortion. And I came to understand it fairly early on because Manushi was one of the few women's organizations which did not shut its door to male victims. If somebody walked in and expressed or explained what had happened to them, how had they been falsely implicated, we never said, we won't listen to you just because you're a man. We took serious note of them, and therefore, whether it was domestic violence law, anti-dowry law, or many other laws, paying close attention to what was happening at the ground, getting engaged in legal aid cases, whether they involved women or wrongly implicated men, had given me a fairly good idea of laws that work actually to protect victims and laws that can be easily misused. And therefore, Manushi began to take a stand that we cannot afford to be insensitive to the abuse of laws. One of the unique features of our own history in India is that, unlike in the West, women have never had to fight alone. Many of the women's rights movements in India, including the recent ones like the 19th century reform movements or the freedom movement, witnessed men taking and playing a leading role in fighting for gender equity, gender justice, and standing against all manners of inequities in society which work to the disadvantage of women. And in such a situation where we've never needed gender war, if women start both misusing laws that are enacted for their protection and worse still, justifying their existence, then I think women lose moral credibility, which is our strongest weapon. What I'm going to discuss today is not just analysis of the actual provisions of the law, but also describe how these laws are working at the ground level and what is it in the anti-rape law in particular which lends itself to easy misuse. Now, the rape law, for those of you who were born after the 1980s or were too young at that time, a major amendment in the anti-rape law took place in 1983 after the rape of a young woman named Mathura in a Hyderabad police station. And it became a national cause célèbre. People felt outraged that the police had gang raped her while she was in custody. So the whole issue of custodial rape gained salience after Mathura rape case. Several new provisions were added to the anti-rape law in order to make it more stringent. Firstly, the law enhanced the minimum jail term for rape to 7 years, with 10 years for custodial rape, assuming that when a woman is in custody of police or maybe in a hospital, wherever she is under care of a government authority, then the crime is far more serious. So, minimum jail term for rape to 7 years with 10 years for custodial rape. In case of death due to brutal rape, there was provision for life imprisonment and even death sentence. So it's not as if the pre-2013 law was very lenient and generous in treating rape accused. But the fact is that none of these provisions, also this law provided for in-camera trial because a lot of women feel diffident about appearing in court if the trial is public and their name is splashed all over. So the provision was for in-camera trial and not releasing or not revealing the identity of the victim in order to give confidence to women in reporting without fear. The truth is that none of these provisions proved effective. And we saw the number of rape cases, not just the frequency of rape incidents, but also brutality continuing to increase. And many began to attribute the failure of law to curb rape to it not being stringent enough. Now, the truth is that most of those who start yelling and screaming that the law is not stringent, make it more stringent, rarely read the law as it exists. And we have in India this tendency to respond with knee-jerk reactions and panic responses whenever some high voltage campaign is launched through media surrounding a particular case which evokes real moral outrage. Now, the next major amendment in the rape law came after the famous Nirbhaya gang rape case. For those who may have forgotten the details, on December 16th, 2012, 6 men, including a 17-year-old, brutally gang raped a 23-year-old student in a moving bus in front of her boyfriend. She was not even traveling alone, but the bus didn't have any other passengers. And after raping her brutally, that included shoving pipes into her vagina and leaving her in a very, very mangled condition, they threw them on the roadside without clothes, in fact. Now, this case shook the conscience of the nation, and rightly so. And there were widespread protests because this happened in the heart of Delhi, and not even it's not even as though it was in a deserted spot. It was, as I said, heart of Delhi, with a lot of traffic moving, with a lot of police checkposts en route. And on December 29th, the victim succumbed to her injuries. And because our rape law does not allow the victim to be named, she came to be popularly referred to as Nirbhaya. Now, the Nirbhaya gang rape triggered not only massive nationwide protests, but also a high voltage media campaign that we need to make the law more stringent. And many of those who demanded the law be made more stringent actually didn't pause to look at what the law provisions already existed in dealing with this crime. And under this pressure of high voltage campaign, the government immediately responded with a knee-jerk reaction, appointed a high-powered commission headed by Justice Verma, who had just retired, to come up with more draconian, more stringent, more strict, more effective anti-rape law. The government was also responding to the fact that there was a concerted campaign, both within India as well as globally, to declare India as world's rape capital. Even countries like China began issuing advisories that women shouldn't travel alone, that Chinese women should be cautious about traveling to India. US also issued advisory. Many European nations cautioned their citizens from traveling, especially female citizens, saying India is the rape capital of the world. And in fact, there were instances. For example, one reported in 2015, the outcome of it is the Indians began to be viewed as some kind of, Indian men in particular, some kind of subhuman species who pounce at women like wolves and don't know how to treat them as human beings. And there's this famous case of a German professor citing rape culture in India to refuse student internship to a male student from India. Now, let's look at what the actual figures are, global comparison. Does India merit the title of being the rape capital of the world? And this is a title we started giving ourselves, meaning our own media and our zealous feminist NGOs began to use this term, and it was picked up globally. Now, if you look at the statistics gathered by UN Office on Drugs and Crime, which tell you how India compares with the rest of the world, India is placed 85th among 121 countries for reported rapes and 39th for unreported cases. So we certainly nowhere near the top. Let me give you some more statistics. The rate of rape, as again tabulated by United Nations Office on Drugs and Crime, the rate of rape in India, which is per 100,000 population, that's how it's calculated, it's 1.9. Global average is 11. Africa is 13. Asia, all of Asia is 4.2. Australia is 25.8. Europe 8.1. North America 21.2. And US 27.6. With Sweden topping the charts 63.5. The highest is Botswana with 92.9. Now, how does it happen that India gets to be defamed in this manner? With active connivance of our NGOs, Human Rights Biradari, the whole human rights community, as well as our own media. None of them challenged, none of them said, let's at least look at global figures to figure out where we stand. And as I mentioned before, the panic response was to appoint this high-powered committee headed by Justice Verma on December 23rd itself, which is within days, within almost a week of the Nirbhaya gang rape case. And its mandate was to produce a report within 1 month, which it dutifully did. On January 23rd, 2013, Justice Verma Commission comes up with more draconian provisions in the existing rape law. And it's noteworthy that the voluminous report it produced, foreign funded NGOs played a very major role in actually writing that report. And many of them even boast about it. And what is most alarming, though the Verma Commission did make a pretense of holding a public hearing on the subject, which is mandatory. Whenever the government has to enact a major new law, it's expected to take inputs from citizens. So public hearings, especially in cases like this where public opinion is already very aggravated, is considered necessary. And I do remember how the inputs I tried to give to the Verma Commission were treated with, I would say, visible disdain. And this is evident from the fact that the farcical public hearing was organized at the fag end of this 1 month when the report was almost ready. If you organize a public hearing just 2 days before, then all those people who were coming up with cautionary advice, sharing with the Verma Commission what precautions need to be built into the amendments, were treated very casually, and none of it found any place in the law. What are the changes that the Criminal Law Amendment Act of 2013 brings about? Earlier, the punishment for gang rape was 10 years to life imprisonment, and in the 2013 amendment, it becomes 20 years to life imprisonment. Then, rape resulting in death or vegetative state, earlier, rape and murder were dealt with as two separate offences, with rape inviting 7 years to life imprisonment and murder inviting imprisonment for life or death. In the new amendment made in 2013, it's 20 years of life imprisonment or death sentence. Then assault or criminal force on woman with intent to outrage her modesty. Earlier, it was imprisonment for maximum 2 years and fine, which is outraging modesty is a very vague term and can be used in a lot of varied situations. In the new law, the imprisonment is 1 to 5 years plus fine. Then another important change, use of unwelcome physical contact, word or gestures, demand or request for sexual favors, showing pornography against the will of a woman, making sexually colored remarks. Earlier, there was no specific provision for this, but in the new law, we have up to 3 years of jail for this, even for words or gestures. Now, you will see later what happens when you don't specify what really constitutes a crime worthy of 3 years imprisonment. Then voyeurism, 1 to 3 years imprisonment, and for second time offense with 3 to 7 years. Assault to disrobe a woman or compelling her to be naked. Earlier, no specific provision. Now, we have 3 to 7 years imprisonment and fine. Now, I'm going to now describe what are the serious flaws in the very definition of rape. I'm sure all of you will agree that if you have to enact a law to punish a particular crime, the least the lawmakers need to ensure that the crime is very accurately defined. You need the precision of a surgeon's wife. You need the precision of a surgeon's knife in defining crimes accurately. But in India, we tend to use butcher's hatchet for doing that. And that's one of the reasons why many of our laws lend themselves to easy misuse. Now, follow this closely and carefully. A man is said to commit rape if he, 1, penetrates his penis to any extent into the vagina, mouth, urethra, or anus of a woman, or makes her to do so with him or any other person. Fair enough. Inserts to any extent any object or part of the body, not being the penis, into the vagina, the urethra or anus of a woman, or makes her to do so with him or any other person. Which means even if you finger a woman with your hands or use other objects, which happens very often in brutal forms of rape, then even that would be. Earlier, it had to be penile penetration, but I think this was a necessary addition, whereby if you shove bottles into a woman's vagina or rods, well, then it should be considered no less, if not more than penal rape. Then third is manipulates any part of the body of a woman so as to cause penetration into the vagina, urethra, anus, or any part of the body of such woman. So far, so good. Now, henceforth, the definition of rape gets fuzzy and more easy to misuse. Applies his mouth to the vagina, anus, urethra of a woman, or makes her do so with him or any other person. That is oral sex. Against her will, without her consent, and I'll explain where the problem areas lie. With her consent, when a consent has been obtained by putting her or any other person in whom she is interested in fear of death or hurt, or when her consent has been obtained while she was intoxicated, or when she is unable to understand the nature and consequences of that of which she gives consent. On the surface, all this sounds very reasonable, but there are serious problems when you go into the details. Now, consent, how does this law define consent? And I'll come to the problem areas in a minute after I've finished with giving you the bare provisions of the Act. Consent means an unequivocal voluntary agreement when the woman, by words, gestures, or any form of verbal or non-verbal communication, communicates willingness to participate in the specific sexual act. Second, and this is very problematic, a woman who does not physically resist to the act of penetration shall not, by the reason only of that fact, be regarded as consenting to the sexual activity. Which means also that no circumstantial evidence is required to corroborate the serious charge of rape. The woman's uncorroborated testimony is enough to file rape case and convict the man. You know that famous sentence in the film, was it Pink? No means no. Sounds very fair. But not when you see what's actually happening on the ground and what's the kind of misuse that has become rampant. Now, under existing rape law, if a woman states that she did not consent to intercourse, then the court has to presume she did not consent. She does not have to show any signs of resistance on her body to allege that she did not consent. The world over, this has been a standard practice, that a woman says she was forced into sex, then circumstantial evidence is taken into account. Was she, for example, lured into a place, into a lonely spot? Did she go there willingly, or was she forced? But now, the burden of proof is on the accused. If a woman says she didn't consent, the man has to prove that she did consent. And the woman does not have to show any circumstance. Her word, uncorroborated testimony, is enough to damn a man's life. And to my mind, this amounts to a total pendulum swing from women being treated with suspicion and saying, oh, they cry rape and they cry wolf, to men presumed to be guilty on mere allegations. And the very opposite of, the injustice they do to women in Islamic law, where a woman is supposed to have 2 witnesses. Now, not everybody rapes bringing 2 witnesses, and witnesses who are on her side. If it's a gang rape, then the witnesses are certainly not going to testify against people who raped. But in our law now, it's a total pendulum swing, and a man is assumed guilty and convicted if a woman sticks to her testimony to the end of trial. She does not have to bring any other evidence whatsoever. And even if all other evidence goes against her, she can say, but I didn't consent. Now, which in effect means that post facto police complaints of lack of consent are sufficient to get a man arrested and sent to jail. 2 people have consensual sex. It could be 2 people in a relationship, or it could be maybe a sex worker who agrees to have sex for money, and post facto the person goes to police station and says she was raped. Well, that's enough. So even consensual sex can be denied as having been consensual, because all you need is a woman's word for it. And what is worse, the law says you have to arrest the man immediately and and it's a non-bailable, cognizable offense, which means bail can't be had easily. And if the woman in addition charges that if you let him out and give him bail, he will be a threat to my safety, then there's no chance of the man getting bail easily. Which in effect means that the punishment begins even before charge sheet, leave alone conviction. Conviction can take many years. But even before the charge sheet is filed, the police have to arrest, send the man to jail. And a man has to prove that he actually got the woman's consent for the sex. Prior to 2013 amendment, the severity of violence involved in rape determined the length of sentence. If the rape was gray area or there wasn't much violence, then but other circumstantial evidence showed that it was rape, then the sentence could be less harsh. But post 2013, judicial discretion has been altogether done away with. Namely, even if the judge is convinced that this is a gray area, that seems it was consensual sex, but if the woman sticks to her testimony, the judge has no other option except to give a 7-year sentence. This 180-degree pendulum swing against the man, assuming him to be guilty the moment he's named by a woman, by a complainant, has really caused havoc to countless lives. The other additional feature that is very troublesome in this rape law is the dangerous equivalence between relatively minor offenses. I underline the word relatively minor offenses with gruesome forms of rape. For example, under this law, touching a woman's private parts or subjecting her to an intimate embrace or body contact or even deep kiss is as bad as having raped her with use of violence. Now, I'm not denying that an intimate embrace or a man touching a woman's private parts without her consent are very offensive. But are they as offensive, are they as serious a crime as a serious rape, using violence and force and much else? Now, does it not amount to belittling the horror of real rapes? Now, does this not amount to belittling the horror of real rapes? And what is more, none of these acts, for example, oral sex, if you say he subjected me to oral sex, or forced a deep kiss on me, or fondled my private parts, none of these can be corroborated by a medical examination. Whereas penal rape or rape with blunt objects, shoving rods or bottles up a woman's vagina, all that can be medically corroborated because it does cause injury. It does show signs if a woman goes for medical examination. But fondling a woman's private parts, there's no way, or he subjected me to oral rape, there's no way that the man can prove that he didn't do that. Because the woman stands by testimony. And that has happened in many cases where men have spent years in jail on the basis of such flimsy charges. Loosely worded definitions of rape provide an easy handle for consensual sexual acts being given the taint of rape ex post facto by persons actuated by malice. And it's happening on a large scale. Because a woman can say she was drunk and therefore she was not in position to give informed consent. Now, at one level, it sounds very reasonable that if a woman was drunk and she was forced into a sex act, then it can be called coercion, a coerced sexual act. But the fact is that in a situation where women are now frequenting pubs, late night parties, in farmhouses, intermingling with strangers, people they don't even know, and this has become fairly common, this mode of socialization. You can get drunk, go to a person's bedroom in one of these farmhouses, or agree to accompany him to a hotel room or to even his own house or wherever, and next morning you go and allege rape and say, I was drunk, so I was not in any position to give consent. What is the other person going to do? The point that I'm trying to make is this. On the one hand, the incidence of high-risk behavior by women, young women, including teenagers, has increased exponentially. It's considered smart and hip and cool to be going to late night parties. And there's another film, Mom, right, where this teenager gets very angry when her mother says, please don't go for this late night party. And she yells at her mother and doesn't want interference. And actually, we're being told parents have no right to control a person's life, a woman's life after she's 18. And even as teenagers, feminists will tell us, why do parents want to control our sexuality? We are autonomous, this, that, and the other. But the point that I would like to emphasize here is this. If you indulge in high risk behavior, then there are certain dangers that come with it. If you're going to late night parties with strangers where a lot of people who you don't know, you're going to intermix, you're going to dance with, you're going to have drinks with, also have drugs. In such a situation, if men take it for granted that you are there because you want a certain kind of enjoyment, that's really what these parties are meant for. That's why they ask people to bring in not just their own friends, but even strange people are allowed to come in, because they are meant to be mode of picking up sex partners. Now, if you've done that and next morning you say, but I was not responsible for it. It could be a case like in the film Pink, whereby the women actually resist, but they do indulge in high risk behavior, which is they are in a farmhouse, and after having drinks, they do go to the private room of the rapist or the gang that has planned to rape them, and they've invited them with that intent. In that case, they actually resisted. So you have still some right to say no means no. But in cases where actually you haven't resisted, how is the man to know whether you are actually willing or it's an unwilling act of sex? And what is important to notice this, that it's these kind of cases of rape that have increased in frequency. And since there is a mandatory minimum 7-year jail, which is, this mandatory punishment, it's important to understand, except for full-fledged murder under section 302 IPC and the actual act of waging war against the state, very few other offenses are punishable with a statutory minimum term. So you brought it in rape, and this alone lends itself to very easy abuse, with police actually very often playing a very active role in encouraging women to file false cases or being part of such gangs that do so, also that they can split the booty. But before I come to that, let me remind people who may have forgotten about the infamous Preeti Jain versus Madhu Bhandarkar rape case. In 2004, an aspiring starlet called Preeti Jain filed rape case against very well-known film director named Madhu Bhandarkar, alleging that he raped her 16 times between 1999 and 2004. All under pretense of giving her role in a film, or she said he also promised marriage. Now, there's no way you can prove whether he actually promised or he didn't, but she's admitting to having had sex with him because she was interested in getting a role as a heroine in his film. Now, nobody can rape you 16 times in the duration of 5 years unless there's some consent, because there's no case that he barged into her house or he drugged her and he captured her and he took her to XYZ place. They met at mutually agreed upon places wherever, even by her own account. Madhu Bhandarkar, of course, denies it. I don't take sides in this case. I'm just narrating the bare details. In 2005, Preeti Jain gave supari of 75,000 to a member of Gabli gang to murder Bhandarkar, because even after she leveled rape charges, he didn't buckle under the pressure. He did not give her a role in any film, but he fought back. Whether he was right or not is not my job to judge. In 2011, Maharashtra police filed a report that rape case was false. But later in 2011, Mumbai court asked Bhandarkar to face trial, and this verdict was confirmed by the High Court. So the case goes all the way up to High Court. But when it comes to the Supreme Court in 2012, the criminal proceedings against Bhandarkar were quashed because Preeti did not follow up, did not pursue the case, she didn't appear, and so the Supreme Court quashed the case. And in 2017, interestingly, Preeti was sentenced to 3 years in jail for Supari to get Bhandarkar murder. Now this is fairly murky, but the point that I would like to make is this, that such like cases where women alleging that somebody promised them XYZ and that's why they had sex, then later on filing rape charge, even without declaring Madhu Bhandarkar innocent, even though Supreme Court has quashed criminal proceedings against. I'm not taking any sides, but the point that I'm trying to make is this. Even if we take Preeti Jain's charges seriously, Bhandarkar can at best be accused of breach of promise, not rape, because the sexual act was in the nature of a sexual bribe that she willingly paid. He could not have for 5 years continued with this unless she was willing. Now, such like cases are coming in droves, and I think that is really what has shook even the apex court, and various high courts have been commenting on how these countless cases that are happening, the false cases that are being lodged, and that too mostly with police complicity in filing false cases, very often using professional gangs of blackmailers. Like there was this case in Navi Mumbai where the High Court ruled that cops were part of this false rape gang racket, and highly placed IT professional was booked in this case. He even went to jail by a woman who had filed 3 more such cases for extortion and blackmail. Now, what is the modus operandi being used for filing such cases? One, of course, you're employed under someone, you want a certain promotion, you don't get it. In many cases, it's true that women have to offer sex bribes in order to get promotion, in order to get a certain job. There is casting couch, not only in the film industry, but even in politics. So I'm not at all undermining the importance of, or the seriousness or the heinousness of cases where women are subjected to sexual humiliation and treated as playthings. But the reverse is happening as often, if not more often. One, it's become very common for women to use dating sites to lure men and then file rape charges. I know of this case personally where they, after fixing a date, they met in a Khan Market coffee house, had coffee, and then this gentleman offered to drive her back home. There was no sex, nothing. And she says, okay, drive me to X location. He gallantly does that. She stops near a police station, says, will you wait a few minutes? I'll just come out. While he's waiting in the car, the police come and say, sorry sir, there's a case of sexual assault on you. And they extort money right there in front of the Thana. And I know of this case personally. Then Facebook friends. People become Facebook friends, make all kinds of pretenses, start dating, start getting intimate, and then use that intimacy, which turns often into physical intimacy of 1 or 2 incidents, and then you blackmail and extort. Escort services. People who provide escort services. The reason I'm saying this is, now escort services is not a very noble profession, but women who enter that, women who become willing partners in that racket of going with men to Dubai or here or there know what they are entering into, know what's at stake, what's expected of them, that they're not being taken ex place just as decorative, uh, you know, that they're not being taken only as decorative dolls for display, but they're expected to provide sexual services. But all such women have now formed gangs. Many such women have become part of well-organized rackets who are filing cases for the simple purpose of, for the clear-cut purpose of extorting money and blackmailing the man for as long as he is willing to fall prey. In fact, recently there was this case of murder by a young college dropout named Priya Seth, comes from a very respectable family of Jaipur, daughter of a college professor. And she had made a profession of luring rich men through dating sites and extorting money and also ATM loot, all by threatening rape case. In one case, she dated a man who pretended to be a millionaire, a very rich man, but when he came, he turned out to be a very ordinary middle class man. And because she realized she cannot get the sum she's demanding of him, she and her accomplices chopped his body into pieces and murdered him. And this is as recent as May 7, 2018. Another very common misuse of rape law is by women in live-in relationships, which turns sour. There have been n number of cases of women actually successfully registering cases by saying, he's been raping me for 3 years, he's been raping me for 8 years, I was living with him because he promised me marriage, and now he's not willing to marry me, so he's been raping me for X number of years. And believe you me, so many men have gone to jail and then either succumbed given whatever booty was demanded of them, or have rotted in jail and got acquitted after spending long years in prison. A very interesting case is one where High Court acquitted a man on June 19, 2016. This man had been in jail since 2011 and he was sent to prison for 10 years. He fought it. He fought his case, and it's only in 5 years later in 2016 that he is acquitted, with the High Court saying that a long-term relationship, live-in relationship, cannot be turned into a case of rape, especially if there is good evidence that the live-in relationship itself was voluntary, there was no coercion of any kind, and it was of long duration. And if you are a well-educated woman of means and you choose a live-in relationship, now there's nothing wrong in having a live-in relationship, but I think it's important for us women to understand that if we want the security of marriage, then we better wait to start living in with a man after he's done the 7 peras, because that's the only social guarantee that you will be treated as a duly wedded wife and be able to avail of all the protective measures that are meant for duly married spouses. You cannot say, I don't believe in marriage, I don't believe in any social constraints, this is a matter between us two individuals, and if the relationship goes sour, the man either refuses to marry or refuses to keep paying you whatever money you want, and suddenly then, or you get pregnant and he still doesn't want to get married, and then you accuse him of rape. If we exercise freedom, we have to learn to be able to cope with the risks that come with sexual freedom. Nothing wrong in having live-in relationship. Even Shakuntala in Kalidas's famous classic has a live-in relationship with Dushyanta. But when he refuses to own her, she comes back with great dignity to her parental home, in this case the ashram that she was living in and raises a child all by herself with, of course, a supportive community. But that's because the community recognized in India traditionally Gandharv, even Gandharv Vivah. Now you've done away with all that legally, and you have laws that distinguish between a legally wedded wife and a non-wedded wife, and you want all kinds of protective measures. You want share in his property, you want maintenance and much else that comes, that legally can come only to people who've gone through the due process of marriage, and you want to defy social norms regarding marriage, then the least you owe yourself and your own dignity is to be able to bear the risks that come with it and not go crying to a police station and to a court of law to say he was raping me for that many years. This particular aspect of misuse of rape law was something that was brought to my notice several years ago by the then law minister Ashwani Kumar, who said that in villages of Punjab and Haryana that he's very familiar with because he comes from that state, filing false rape cases with the connivance of one's husband against his elder brother or some relative in order to take over his property. You know, if there's an elder brother who doesn't have adult sons but has land and valuable property, very often men encourage their own wives to file a false case and threaten the man with jail term unless he signs away property. And this is happening even in so-called traditional rural India on a fairly frequent scale. Secondly, and I have come across several such cases, in cases of false dowry cases, 498A, cruelty, which are also as draconian and as ill-conceived as the anti-rape law, there have been instances whereby an estranged wife filed rape case against father-in-law and brother, false rape case against the father and brother of her husband in order to blackmail the family into giving her a chunk of their property or a hefty settlement. And in a couple of such cases that I know of, the man committed suicide because said, this is the only way I can free my family of such ignominy, because it's because of me that they are suffering. So if I disappear from the scene, maybe this will end. There have also been cases reported in newspapers of wives settling scores with estranged husbands, getting their own daughters to file false cases of rape against fathers. That's how far this has gone. Now, evidence of misuse, it's not just me and stray newspaper reports that are talking about misuse. The Delhi Commission for Women, its own statistics indicate that immediately following the 2013 amendments to rape law, there's been a disturbing spurt in filing of trumped up rape complaints, and its own, the DCW statistics tell us between April 2013 and July 2014, that is within a year of the amendments, 53.2% of the 2,753 rape cases filed in the capital were found by DCW to be false. And DCW is supposed to be an organization for protecting women's rights, this Commission for Women. And if they are saying so, we better wake up. And the acquittal rate was 78%. Now, they also found that revenge was the most common reason and motive behind false complaints. The Hindu survey, the leading national newspaper, the Hindu, also had done a survey, and it found that 20% of 583 rape cases in 2013 ultimately wound up because complainant either did not appear or withdrew her charges. Another 25% had to do with alleged breach of promise to marry, which is the live-in relationship or having an affair which turns sour and then you allege rape. Out of 460 cases which were fully argued before Sessions Court, nearly 30% involved elopement of the boy and girl. So, youngsters elope and their parents of the girl will say he abducted and he raped her, and young men then end up in jail, their lives ruined forever. In 67 of 174 cases of elopement, the girl initially admitted that she eloped of her own volition. And yet, as I said, 7 years of jail or 10 years of jail or whatever else. I just mentioned that 30% of rape cases, as I just mentioned, in the Hindu survey, 30% of rape cases involved elopement of the boy and girl, followed by a complaint of abduction and rape by the girl's family. Now, in this, another supposedly well-meaning law aids in the registration of false cases and misuse of this law, namely POCSO, which is law for protecting children from rape and sexual assaults. This is because in India, the age of consent for saying yes to sexual act has been unrealistically pegged at 18. Now, we all know that teenage sex is common worldwide, including in India. On the one hand, we argue that parents have no right to control the sexual autonomy of girls. They must have freedom to explore their sexuality. On the other hand, we have a law which says even consensual sex by a young girl below 18 will be treated as rape, even though it could be with a fellow teenager. And the reason I say why age of consent is unrealistically pegged in India at 18 is because elsewhere in the world, in recognition of the fact that teenagers can't be controlled from indulging in sexual activity that easily, so the age of consent is much lower. In Italy, it's 14. In Germany, it's 14. France, 15. Norway, 16. Netherlands, 16. Switzerland, 16. United Kingdom, 16. It used to be 13 in United Kingdom. The point I'm trying to make is this. What do you expect parents to do? Put restrictions, put their daughters under tight, vigilant control to prevent them from indulging in sex at 18. If parents take action against girls for having premarital sex, we call them authoritarian, we call them all kinds of names, and we think they're being retrogressive. But here, by law, you're saying anybody having sex with a girl below 18, even though she consented or may have taken initiative, is to be treated as crime by her sexual partner. It's not that she's sent to jail. She's assumed to be a victim, no matter what her actual role in the case. Now, this double-sidedness is again leading to a lot many tragedies in the lives of young people. And you know, as a teenager, if you've already spent a couple of years in jail under POCSO, your life is marred forever. Now, false cases targeting men don't just destroy the life of the man, they destroy whole families. Apart from deprivation of liberty, as in the case that I just described, where the man had already spent 5 years in jail on a false rape charge, apart from deprivation of liberty, there's also irrevocable loss of reputation, not just for the targeted individual, but his entire family. Imagine your old parents, your children, your wife, they can't show their face in society. Their lives are marred too. To be taunted in school as having a rapist father is not something that children can take easily. And therefore, they go through bigger trauma than the man actually facing that trial because they can't even fight back. and the lethal impact of media trials, especially in the case of high-profile cases, where the accused is declared guilty in primetime TV. Now, while the identity of the woman who's accusing somebody of raping her is protected, unless she wants it to be known publicly, in most cases women choose not to, but the identity of the man and his family is not protected. Their faces are all over TV and front page of newspapers. And when they are acquitted, now in this case that I just cited, nobody expressed apology, regret, and there was no TV show on what's been the fate, what trauma he went through. So while on the one hand we have excessive zeal with media trials, with some TV anchors insisting that the man be executed right there, then and there, and the police commissioner announced right then and there what he's going to do with the person. It also, we shouldn't forget, even if you've been in jail for 2 days or 1 week and managed to get bail, you've lost your job, you are not employable thereafter, so you're economically ruined, you are financially ruined, and your reputation is gone forever. Given this backdrop, it came as no surprise when the Supreme Court of India, in Sushil Kumar versus Union of India case, cautioned against legal terrorism. And I quote from this judgment: "We come across a large number of such complaints which are not even bona fide and are filed with oblique motive. The role of the investigative agencies and the courts is that of watchdog and not of a bloodhound. It should be their effort to see that no innocent person is made to suffer on account of unfounded, baseless, and malicious allegations." The court added that by misuse of the provision, a new legal terrorism can be unleashed. And it was talking about precisely these kind of cases. In Arnesh Kumar versus State of Bihar judgment in 2014, the Supreme Court issued directions to all police authorities and magistrates for well-defined due process to be followed before arrest or authorizing detention. And the court ruled that no automatic arrest detentions should be made by the police or magistrates even in non-bailable and cognizable offences, and police must ensure that conditions precedent to making an arrest or authorizing detention under criminal code procedure must be satisfied first. In other words, please investigate. This is telling the police, please see if there's a prima facie case. Don't just go by mere allegations. Don't rush in to arrest people. Please take care that you don't end up sending innocents to jail. The Law Commission of India also, in 2003, the Malimat Committee report made vital recommendations regarding rights of the accused and preventive measures required to prevent misuse of criminal laws. And they suggested amendments to them. But that's really not what has happened. And as I said, all kinds of and all manners of false cases by professional sex workers as well as well-organized mafia gangs are now misusing this law, whereas genuine victims of rape are not getting justice. I think this is the key. It's not as if the draconian law has enabled genuine rape victims to get justice. In their case, the police will mess up with evidence, they will not do due diligence in collecting the viscera, samples, vaginal swabs, etc. at the right time, and they will help the accused if they are paid off suitably to escape. So while genuine victims who cannot pay off the police, who actually have suffered traumas, get very little help from the police despite the such a stringent law in women's favor, false cases have become far more common, with accused having already suffered long years in jail even before the trial has begun. Another important thing, it's not as if number of rape cases has declined. I can show you charts which show how the graph keeps going up, both on account of genuine rape cases as well as false cases. But what is most alarming? Today, the brutality of rape has become truly worrisome. It points to a very new pathology which we are not paying attention to. Those who assume that rape is all about sex and uncontrollable sex urge ought to take notice when even little infants are not being spared. There have been cases of 11-month-old baby, 6-month-old infant girl being raped. Now, what kind of sexual satisfaction can you get from raping that little tiny being? Or rapes getting brutal. An 8-year-old or a 12-year-old being not just subjected to gang rape, but a body being mutilated, chopped up in pieces, burned to death after the brutal act. That clearly shows that these rapes have nothing to do with sex and sex urge, because then don't act like a demon after having satisfied the sex urge. The brutality that we witness in rape cases of today tells us that we are sitting on a time bomb. We're not paying attention to the fact that India and globally, we are producing a very vast army of lumpenized youth who think nothing of mauling a woman's body and who think that she should be not just a plaything, but she can be done away with once that urge is over. Anybody who gets addicted to watching pornography, especially hard porn, then loses all sense of morality, balance, and ability to control sexuality. And we are not, the very same people who want the rape law to be stringent will not allow us to ban pornography because they say this is freedom of expression. Though there is clear evidence that brutality in rapes, the frequency of rapes, and the kind of mauling of the body that takes place is closely related to hard porn that kids start watching from a very early age, is largely responsible for this epidemic. And what is most amazing and alarming is that gang rapes are being broadcast as proof of machismo. The rapists don't even hide it anymore. They're posting with such a draconian law in place. How is it that young men gang raping their own girlfriends after inviting them for a date and then sedating them, then post those videos on social media themselves, boasting about it? And such cases have become rampant. They are used to blackmail the woman and also to show what macho mardangi they displayed. So clearly then, draconian law, it's not the severity of punishment, but the certainty of punishment that curbs crime. And somehow all the zealous reformers that keep asking for law to be made more and more stringent, what more can you do with law? And yet it's not under control at all. It is ironical that against this background of utter failure of draconian laws to curb the incidence of rape on the one hand, and on the other hand, growing misuse, gross abuse of those very same legal provisions for filing of rape cases and destroying countless lives, suddenly an NGO, a feminist NGO, files a petition in the Supreme Court demanding that marital rape be treated as a distinct offense and a special provision be added in the anti-rape law to deal with marital rapes. The petition filed by this NGO argues that the existing laws amount to a state-sanctioned license granted to the husband to violate the sexual autonomy of his lawfully wedded wife, and is therefore a violation of the right to privacy granted to the wife under Article 21 of the Constitution. Why? Because we don't have a special law dedicated to dealing with marital rape, rape in marriage. The second argument is marital rape as separate from general rape amounts to discriminating between two categories of women, namely those raped by husbands and those raped by men who are not their husbands. Therefore, it violates Article 14 of the Constitution. Now, it's a very clever use of fundamental right to equality being misused with a very sinister intent. Now, I'm not denying that there are a lot of cases of abusive marriages where sex is used as an instrument to humiliate the woman, and there are also a lot of cruelties inflicted on the bodies of women by their own husbands. I've had cases where husbands would use cigarette stubs to burn their own wife's private parts, or inflict all kinds of cuts and use a lot of violence, force a lot of sexual acts on the wife, which she finds abhorring, and all inspired and motivated by watching hard porn. Now, when you start subjecting your wives to what you see happening in hard pornography, well, then it is indeed very cruel and very brutal. So, while not denying that a lot of husbands do treat their wives brutally and do not take their wives' wishes into consideration when engaging in sex, but to bring in marital rape as a separate category, we need to understand A, what are its implications, and what is the motivation behind it. Because there are plenty of provisions in the existing laws to cover sexual violence by husbands. And to my mind, the timing of the frenzied demand for enacting new law to cover marital rape is in itself revealing. At a time when Supreme Court is saying that the existing provision of anti-rape law amount to legal terrorism, can unleash legal terrorism, then you come and say, please extend that legal terrorism further, even to marriages. And so, here we come with this demand that new amendments be made. Now, existing laws are more than adequate to cover sexual cruelty in marriage. For example, in 1983, Section 498A of the Indian Penal Code had defined a new cognizable non-bailable offence, namely cruelty by husband or relatives of husband to wife. Now, look at the all-arching definition of cruelty and see whether or not it covers sexual violence. The definition is, whoever subjects such woman to cruelty shall be punished with imprisonment for a term which may extend to 3 years and shall also be liable to fine. And cruelty is defined as any willful conduct which is of such a nature as is likely to drive the woman to commit suicide or to cause grave injury or danger to life, limb or health, whether mental or physical, of the woman or harassment of the woman or any person related to her. Now, the point is, when cruelty includes physical and mental torture, does sexual violence not get covered adequately by this clause? Isn't rape, that is sex against a woman's wishes, a brutal form of sex, is it not cruelty? It's adequately covered. But they're not satisfied with this. You know why? Because under Section 498A, you can punish a man only for 3-year jail term, whereas the new rape law says and prescribes a minimum 7-year jail term. Well, then there is the overarching definition of domestic violence in DV Act, in Domestic Violence Act, enacted in 2005, which also covers sexual violence. Let me go through this definition. Any act, omission or commission or conduct of the respondent shall constitute domestic violence in case it harms or injures or endangers the health, safety, life, limb or well-being, whether mental or physical, of the aggrieved person, or tends to do so, and includes causing physical abuse, sexual abuse, verbal and emotional abuse, and even economic abuse. When the Domestic Violence Act already covers physical abuse, sexual abuse, and even verbal and emotional abuse, with plenty of safeguards provided for the woman to seek redress, including appointment of protection officers, with shelter homes, medical facilities, legal aid, all to be provided by state. And it also enables the affected woman, and that's very significant. A woman who says, my husband is subjecting me to physical cruelty, sexual cruelty, economic abuse, verbal cruelty, can seek orders against her being evicted from the marital home, and even barring or restricting the accused husband from entering his own house, which is, you can actually prevent a man from entering his own house if you charge a man under Domestic Violence Act. The court can give you orders that the man is to keep out and you cannot be evicted. Now, all this exists already, but the reason they insist on a new amendment is because the term rape is not mentioned in either of these two laws. And I don't understand why this obsession with the term rape. In many countries, rape is now treated as an antiquated term. They will talk about sexual assault, sexual abuse and all that, but not necessarily use the term rape. In any case, does sexual violence not include rape? But as I said before, the reason they insist on a new law is because under the existing law, you can have civil remedies, keep the man out of the house as if it's not a punishment big enough. It at least saves you and protects you from further rape, but only 3 years jail. Now they want at least minimum 7 years jail. The point that I would like to make is this: if a woman is really undergoing such severe humiliation and sexual abuse, the answer to that is divorce. The answer to that is not you go through it for years and then you send him to jail. And ironically or tragically, genuine victims of domestic violence rarely want to use these harsh provisions of sending their husbands to jail, genuine victims, because for them, the husband who tortures them is also the father of their children. They want their children not to grow up with the stigma of having a father who's accused of rape and is in jail, has spent 7 or 10 years in jail. So they say, get me free. I mean, having dealt with countless legal aid cases, I can tell you most genuine victims will say, for the sake of my children, I just want freedom. I want divorce. And to me, that's a dignified way. If the marriage is so insufferable, then the woman must take courage in her own hands and not just be an avenging deity. Now, the problem with having marital rape, regardless of whether it's 3 years, 7 years, 3 days, or 300 days of jail term, is this. Already, thousands of men have been falsely implicated under domestic violence law, anti-dowry law, because it has similar idiotic provisions, and have committed suicide. Lakhs of men have been falsely implicated already under 498A and similar thoughtless provisions of anti-dowry law. And thousands of men have committed suicide and countless families have been destroyed because our newfangled laws carried the mistaken assumption that women are too angelic to book false cases and men will always be brutish and guilty. So they are more vulnerable. Now the point is, when you say marital rape, not just sexual abuse, and the rape law says you don't have to have any sign of struggle, no sign of injuries on your body, no circumstantial evidence, a woman's word is enough to send a man or even her husband to jail, then what we need to ask is, what safeguard does a man have? How does a husband protect himself from false charges? Do we want that every bedroom be installed with CCTV camera and every interaction of physical proximity between husband and wife be recorded so that the man can then prove that this didn't happen? At least after he's been to jail, in court of law, he can show evidence. How is a man to protect himself if after a consensual act, the next day, if women can falsely accuse their own father-in-law, brother-in-law in order to extort money, what is there to prevent them from using, if they're already misusing 498A for extortion, then what is to stop them from using this? And the important part here is this: if you file a false dowry case, you still have to prove it through court of law. You still have to provide evidence that dowry was actually given and threats were made and demands were made. But here the law says a woman's word is enough. If she sticks to it, you're finished. Now, in a situation where a husband and wife routinely share the same bedroom, same bed, how are we to tell that a particular act of sex between them or an act of intimacy between them was rapist in nature, or was it consensual and voluntary on part of both of them? A, you have to have CCTV cameras, and let's have a law which says before you get married, please ensure there are CCTV cameras in your bedroom, in your bathroom, in your kitchen, living room, wherever, so that there's no place which is free from scrutiny. Or before every hug and kiss and act of sex, a man would have to bring a 10 rupees ka stamp, court paper, and say, will you please sign, or take a video recording. Tonight the act of sex between us is voluntary. I shall not detract from this statement, and I assure my husband no false charges will be leveled tomorrow morning. Now the point is, when there's no way that the man can prove that he was not guilty of a certain crime, to make the law so one-sided is truly bizarre. And we should really consider, are women willing to suffer such invasion of privacy, which is bound to happen if we insist on having laws which make men totally hapless and helpless against false charges. And the fact is that the increasing number of false cases, there was this very moving suicide note left by Arvind Bharti on 13 December 2017, and the police wouldn't even arrest the wife. Here they had gone through a divorce after she'd filed false cases against him, 498A, anti-dowry. They'd fought all those cases, he'd already been to jail, they were proven to be false, he came out, and she wouldn't leave him even then. And in the suicide note that he left behind, he says how she threatens to book him under false rape charge so that he then can't come out even on bail. Those who think that only men are abusive and why would women file false cases should remember that under 498A, there's an epidemic of false cases already. 2.3 million were arrested under 498A, that is cruelty in marriage, between 2000 and 2014. And what is interesting or tragic is that more than 1.5 million were found to be not guilty. Half of them not guilty, but many others just didn't reach the courts. Settlements were made in between because the cases had been filed mainly for the purpose of extortion. 2.3 million men arrested, and number of convictions are only 2,76,000, with 1.5 million facing full trial and being declared not guilty, while many other cases being withdrawn or settled out of court. And suicide rate among married men today is twice as high as among married women. As per the data of Bureau of Police Research and Development, for 2015, it says suicide rate among married men on account of marital discord is more than twice as high as among married women. Of 91,528 men who committed suicide in 2015, 64,534 were married men. By contrast, of the 42,088 women who committed suicide, 28,344 were married. Now, my feminist friends argue that so what if men are committing suicide? For centuries, men have made women suffer. Women have been at the receiving end. So big deal if men are now at the receiving end. They better know what it is to be vulnerable. But I think this is a very false and a very harmful, self-harming argument, because by justifying false cases, by inflicting this kind of terror and tyranny in society, you're tearing asunder social fabric. And when family as an institution is destroyed, when men and women become so terrified of being in each other's company, this is not good either for men or for women, and it will only create much greater bitterness and much less ground for healthy relationships. Because if you're forever thinking, she may send me to jail, God knows what kind of revenge she will take, this kind of mistrust becoming the founding rock of male-female relationships is spells doom and destruction for entire society. And what we need to recognize is this, that behind such ill-advised draconian laws is the hand of foreign-funded NGOs who've been as though assigned the job of tearing asunder our social fabric on all fronts, through marriage laws, through rape laws, SC/ST Atrocities Act, name it. They have the monopoly of making laws. In the last 30 years, the government of India seems to have altogether outsourced lawmaking in the hands of foreign-funded NGOs. Not even NGOs, only and mainly foreign-funded NGOs. Even the Law Commission will only consult them. It does not even take into consideration what the rest of society is thinking, as long as these foreign-funded NGOs, which also have very cozy relationships with the media, both national and global media, and who can, within hours, unleash high decibel hysterical campaigns on this or that issue. To keep them placated seems to have become the major business of government. And I remember how I've been to pleaded with 3 different law ministers, saying many of these laws are causing enormous damage to our society. They are destroying families, because when you book a man on a false charge, you're actually destroying his entire family, his old parents, his young children, his wife, his sisters, his brothers. Nobody is left untouched by that one cruelty. And I pleaded with our law ministers, first of the UPA government and then even this current government, saying please at least appoint a task force to review these laws and find out how we can tweak them in a manner that abuse is not easy, build safeguards against abuse, and review them to see where all the problem lies. And you know, the answer I got is, Madhuji, please do not expect us to commit political harakiri. These feminists will slaughter us, and we dare not take them on. I even pleaded with the former chairman of the Law Commission, saying, you don't have to fight elections, you at least can do so. Please appoint an empowered committee to report to you within a specific tight time frame to review the functioning of these laws. Now, this former Law Commission chairperson, otherwise a good judge, asks me, but what does XYZ think of it? And he named some leading foreign funded feminist NGOs. I said, well, they obviously are in support of these laws because they were part of the process of making them. So he says, in that case, Madhuji, I respect you a lot, but I dare not go against what they have set as the established wisdom on these issues. Now, no self-respecting society can afford to become a hostage to a handful of foreign funded NGOs who've been planted here with specific political agendas, and yet we seem helpless in front of them. Now, what's important to also remember is that in the Indian Penal Code, Section 182, 199 and 211 provide provisions for punishment of false cases. Any move to have these sections actually operationalized, especially when it comes to women's rights, even judges dare not, because they'll be pounced upon. That's how fearful our society has become. I would like to reiterate that there's no denying that plenty of women go through cruel marriages and very demeaning, brutal sex at the hands of their husbands. But the answer to such marriages is divorce, not suffer years of dehumanization and then enact laws that brutalize whole society. And lawless, draconian laws don't just harm the targeted individual, they also destroy faith in law and order machinery itself. And any society where we can't trust our police, where we can't trust our judiciary to give us justice, where our laws themselves are so bizarre and so lawless that to expect justice is seems unreasonable, is to make society, ye bhi sentence nikal dena. At the end, what I would like to, I would like to conclude by saying that laws work only when they are used as careful doses of antibiotics. Just as you can't make antibiotics a substitute for food and healthy lifestyle, and if you treat a person sick with some ailment with just medicines and antibiotics, you destroy even the healthy bacteria of that body and destroy the immune system. Similarly, overuse of law can destroy the entire social fabric. The analogy I like to give is, कानून को आटे में नमक का काम करना होता है, नमक में आटे का नहीं. If you reverse the proportion, well, then it's not worth eating. Both atta and namak are necessary, but it's the proportion that decides whether they are edible. The need of the hour is to professionalize our police force, make them efficient, make them accountable, give them better training, and make them more responsive. And then judicial reforms in order for speedy justice and fair trials, due process trials. In all these laws, we've done away with due process. When arrest and jail comes before the trial has even begun, that means you've done away with due process. And then that means that's the end of expecting justice, because the man has already been punished before conviction. Secondly, we need surgeon-like precision in defining crime. When a body part is diseased and a surgeon has to remove it or fix it, if he starts messing around clumsily and instead of touching the kidney goes and removes the liver and damages the heart, well, then such a person would be called not even a quack, he'd be called a criminal. But our laws really are now full of such criminal quackery. Third, it's very important to have a sense of proportionality in punishing different categories of crime. A forced kiss and a brutal rape cannot be put in the same basket. Fondling of a woman's private parts or allegations of fondling her private parts cannot be put in the category of gang rape. They have to be treated differently, and there has to be proportionality in the amount of punishment for different categories of crime. Thirdly, we have to have effective deterrence against misuse of law and strong punishment, not just for litigants if they mislead the court, but even lawyers if they encourage their clients to misuse law for blackmail and extortion. Today, the biggest threat is coming from the legal profession because they, like the police, gain a lot from false cases and they split the extortion and the booty money. So, unless we work in this direction, and finally, most important of all, we really need to examine why globally we are mass producing men and women who are treating sex as a sadist sport. And close look at the factors that are making consumption of hard porn a statement of sexual freedom, and the whole industry, the sex industry, the manner in which, the direction in which it is going, I think needs to be scrutinized afresh. Finally, the most important point, crime control cannot be left only to the police and judiciary. Societies which completely surrender this power to the police, to the state machinery, become more crime infested and more unstable. Crime can be best controlled by neighborhoods and communities keeping a close watch on young people, on their own people. Stable villages in India, for example, where if a man misbehaves with a woman, the whole village will get together and subject him to public humiliation. I've seen it happen even in Delhi, in stable neighborhoods. The fact that a young person misbehaved with a young woman, the whole neighborhood got together and made him publicly apologize and say, no such act will be, without calling the police, just public condemnation and a very firm statement that such bad behavior will not be tolerated by us. And it's only stable neighborhoods which take responsibility for their own safety and the safety of their neighbors, which make a resolve that there'll be zero tolerance for abuse of women or abuse of anybody's rights, and not just rely on calling the police, that can really curb crime. So basically strengthening social monitoring. It's become too fashionable to say none of anybody's business. Parents have no rights to tell me what I should do. Parents have no rights to interfere once I'm an adult. My life is my life. No, none of us is capable of ensuring safety for ourselves if the social environment around us remains indifferent to assaults on us. So to remain connected with your society, with your neighborhood, with your village, and to keep a collective watch on the conduct of both men and women, that is actually the only way to make our society safe, instead of putting everything on the doorstep of police stations and law courts. Thank you.